Tonight we're very fortunate to have Ron and Sherry Palmer with us. Ron is a constitutional scholar. Both Ron and Sherry are strategists. In addition to their professional expertise, their lives have been personally touched by experiences with the family court system. Their new book, Not in the Child's Best Interest, is receiving high praise and acclaim from parental alienation experts such as Linda Gottlieb, and they are being highly sought after for interviews and speaking engagements. So tonight, PAAO USA North Texas chapter is very, very fortunate to have Ron and Sherry Palmer with us, unveiling their new presentation for their groundbreaking book, Not in the Child's Best Interest. So please join me in welcoming Ron and Sherry Palmer.
Thank you, Wendy. I think I've met several of you, and I just want to introduce myself a little bit for those that I didn't get to meet. And I'm Sherry Palmer, obviously, and just wanted to let you know that we do understand the process, unfortunately, and the pain of what all of you are going through. I still currently have 2 children that are adults now that are not including me in their lives, and I have 2 children that I finally got the courts to give me primary so that I have authority in their lives again. We've had to work on working with them and working through all of the things that they were taught to believe about me and my husband. So we do relate. So getting to the presentation, I just wanted to start with the pain part of it. There's nothing more painful and frustrating than watching your children get hurt and feeling helpless. And you can tell it's still very emotional for me because as a parent, you think that you're going to be able to protect them, at least until they're 18. You know, from being in situations that are going to hurt them, especially from people that you believe to carry out. So, I remember the first time, and I'm sure you remember the first time your child was withheld from you. So let me just kind of take you through that a little bit, some of those emotions real quick. As you can tell, I had to revisit those, and that's really difficult to do. But I'm sure one of those was panic. The first time you couldn't get your child on your time. And then some of you might have felt fear when people you thought were there to protect you didn't help. Pain, which turned into urgency. And this board's probably going to be small for me here, so just bear with me. And shock. So, what do? You hire an attorney, right? So here's your attorney. You think he's going to protect you. You think they're going to make it all stop. Okay? After they do everything they tell you to do, what are you left with? It's not your kids. Feeling powerless. Sorry about the writing. Penniless. Not feeling penniless, but they make you penniless and cost you tremendously to get that kind of protection you thought you were paying for. You're alone. Because now your representation's probably dropped you. They may even be suing you. So you're going through all this. This causes you to react, which leads you into depression and some PTSD. So now you're alone, you're feeling hopeless. This is the result you got because you listened to your attorney. So today, we're going to talk about turning this devastation, pain, and anger into strength by empowering you and helping you learn how to be more effective. when we take this devastation and this anger and we focus it properly, we can actually learn to use it as energy. I know it sounds kind of strange, but it is a form of energy, and you'll feel less helpless if you actually know that there's something you could be doing to help you change what's going on, right? So that's what we looked for, my husband and I. But first, I realized that I had to change my views because I thought they knew everything. You know, I paid them to protect my rights, right? But they never told me I had any rights. So I had to change my views in what I was going to be able to achieve. Because at first I thought that I had to battle everything that they accused me of. And that's one of the first mistakes I think people get into, is they think that they have to defend everything that they say you did wrong. And what do you end up? A very expensive, litigious battle that goes nowhere and ends up forcing somebody to choose between you and the other parent. So having something empowering to channel my energy into was helpful for me, and I hope it will be for you as well. Listening to attorneys got us bankrupt and childless. And I'm not telling you not to do what your attorney says, so please don't misunderstand. You'll understand as we go through the presentation. We're just saying just strictly following blindly got us into a bad situation. And that's why it's so important that you start to learn these other ideas so you can keep yourself out of those bad pathways, okay? We knew there had to be a better way. So while there are no perfect ways to win this war, there are some ways that are more effective than others. We are sharing some of these with you today. And the first idea that I want to share with you that I think people forget, even the attorneys practicing and the legislators, is attorneys, judges, and the legislators have a responsibility and a duty to uphold your constitutional protections. And I wish, and I know I wrote this on one of Kevin Avard's recent interview videos, I wish that we could actually require attorneys and judges to have to tell you that you do have parental rights, but we're not quite there yet. So it's your job, as we the people, to remind and advise them when they are not doing this. It's your job. You're going to have to turn the panic and the fear and the pain, the urgency and shock into empowerment. So you're going to play their game, but you're going to change the rules on them. And it's a very scary process because all of you know if you say the wrong thing or you talk about the wrong things, you're afraid somebody's going to turn around and use it against you. And I have my two younger ones and I don't want to lose that. So there's always that pressing fear too, that somebody's going to look to attack again.
Yeah. So you know how Sherry said that wouldn't it be great and seem appropriate if your judge told you you've got constitutional rights? Did any, raise your hand if your judge told you that in court? Nobody?
Kind of like, my vision is sort of like a Miranda rights reading, you know, where they tell you immediately when you're served with these types of things that you do have the following rights. And then I envisioned, and Ron came up with this idea, that they would need to require you to actually put a written waiver down if you were going to forfeit any of those rights, so that you weren't accidentally doing it in court, which is what happens to so many, which we're going to share with you, so you know when you're actually forfeiting.
Okay. So what we start with here is this crazy idea that we have a constitution, right? It's supposed to be the preeminent document in this country, the basis of all of our laws. It applies all over the place, and we see people getting their rights upheld all over the place. But when you go into a family law courtroom, you do not find the Constitution at all, right? About the only place you'll find the Constitution is when they talk about equal rights between the sexes, right? So at one point, years ago, they used to give all the kids to the father because kids were property back then. And then we actually included a case in the book, I think it might have been from Kentucky, where they actually talked about it, the Supreme Court of Kentucky, about how this child was property and therefore it was allocated as property. After that, parental rights became involved in liberty interest under the 14th Amendment. So we started to define it as you have a liberty right to share a relationship with your child, which is different from property right. And so we moved away from property rights, And women's rights became a big deal. So we could no longer give children just to the men. So then they started giving children just to the women. And so we have this tender years doctrine, and only the mother can take care of the children in these younger years. So what the courts were doing was discriminating. They started discriminating with men because children were property. Then when children became part of a liberty interest, a constitutional liberty interest, then they said, oh, and we had equal protection between the sexes, they started saying, okay, well now we give the kids all to the women and discriminate against the dads. And now we've come to a place where they say, well, we can't really do either one because we have equal protection of the sexes, so they just discriminate arbitrarily now. They have to continue the discrimination that they've always done. They have to arbitrarily find ways to pick one better parent over the other, right? And they'll find anything they can find to do this. And the reason they're doing it is because they've got 300 years of arbitrary decisions around children and having this complete and utter power to do anything they want, and they really don't want to give it up. Right? But when we look at the Constitution, and after our battles kind of calmed down, we got a chance to really look into the Constitution and the constitutional cases around family law. And when we put this book together, I was expecting a very little book. I thought this was going to take a month or two. It was going to be pretty simple. We got into it, and I found so many cases that say parents have constitutional rights to care, custody, and control of their children all over the place. Cases that say you can only take the child if their child is in clear and present danger by the parents. Right? And we have all of these rights, none of which are applied in family law and divorce. They're barely applied when it comes to fit families having their children taken away by CPS. We all know stories about CPS going crazy. They came after me. They violated the law. Right? We were able to beat it. Right? But what we knew beforehand, but we really found the details that support all of this, is that the Constitution doesn't give us our rights. What our founding fathers said is there are certain natural, unalienable rights that come to us by either God or nature, and they exist before the government exists. And our founding fathers very clearly said we came together to create this government not to grant our citizens rights, but to ensure that our citizens get those rights against all of the people that are trying to take them away. Right? And they put all kind of special balancing of power all through the Constitution between states' rights and federal government's rights, between the three equal branches of government, the judiciary, the executive, the legislative. And they balance this power so that it becomes very hard for people to take your rights away. And we've been very successful in a lot of areas. Unfortunately, family law is just a horrible place for a constitution. It doesn't exist. So if you look at the cover of our book, that's what the cartoon is all about on the cover of the book, right? You've got a family law judge and two attorneys up here. The attorneys are saying, you know, Your Honor, we want you to decide the best interest of this child. And then the judge says, well, I certainly don't need the Constitution for this, because according to the Constitution, I don't have that authority. But since you're both asking me to do this, then we'll go for it. And the states have statutes that are clearly unconstitutional, but they have statutes that give the judges cover that basically say they can do that. Right? The reason they continue to do this is because nobody has framed these cases properly and presented them up the appellate chain in the courts to get rulings specifically in divorce to say these rights apply and to force the states to change their behavior. They always have wiggle room, and too many people go in and say, I have constitutional rights, and that's it. They don't put any argument behind it, they don't put any of the details, they don't cite the proper cases, and they don't tie all these cases together because they're all over in different places. Some of them don't even have to do with family law at all, but they set basic legal precedent and standards and ways of evaluating things that we draw. And then you pull it all together and you have a very coherent, focused ability to argue that parents have rights under the Constitution. They are unalienable. They existed before the government ever came around, and we created this government so that we could protect those rights. And it's about time the family law court judges start protecting those rights. All right? So all of this is based on the Constitution. All right, click again. One more time. All right, so we start out here with the judge. In the traditional family law system, The judge has broad discretion to determine the best interest of the child, right? That's what all the state statutes say. They have near absolute power to do this. The minute somebody files for divorce, they wipe away all of your constitutional rights, and they all get vested into the state. The state owns your child, and the state is going to determine who gets that child, how often they get them, all the conditions. They determine everything, right? How do you stop this? Well, again, the basic idea is when the statutes and the attorneys stand up here and say, Your Honor, you have broad discretion, we want you to determine the best interest, then the judge can do whatever they want. But what we're saying is you start boxing the judge in. First thing you do in your pleadings and orally, and certainly with your lawyer, is you say, my parental rights are a fundamental liberty interest under the Constitution. And that word fundamental is critical here because we have lots of liberty interests that aren't protected as strongly as fundamental liberty interests. Right? Your financial interests are liberty interests, but they're not protected anywhere near as strongly as a fundamental liberty interest. When we talk about fundamental, we're talking about your right to freedom of religion, freedom of speech, freedom to own a gun, right? The right to have a jury trial, all of these things. These are fundamental liberty interests. And there are many, many others that aren't written down in the Constitution. They're called substantive rights, but we couldn't exist without them. The right to travel freely state to state. It's nowhere in the Constitution that says we have that right. And yet the Supreme Court has said very clearly that that is a basic tenet of the idea of our federal system, is that a citizen of the United States has absolute right to travel from state to state, right? And they can't block it. They tried. And the Supreme Court said this is not going to happen, right? You'll hear a lot of people say that if it's not written down in the Constitution, you don't have it. It's not real. But that argument doesn't hold water. There are countless rights that they would not give up that are fundamental, that are protected. And parental rights is one of those, and the Supreme Court has said very clearly, absolutely, that we have this right. Right? Click again. So, there's this idea of how strongly these rights are protected, right? And the Supreme Court has a series of tests, and they review certain things that come to them with different levels of attention, different levels of focus, different levels of rigor around what the state can and can't do. There are three of these. And the first one is the rational basis test, and if a law has some rational basis to rational relationship to what the government's trying to achieve, then they're going to let it stand. And a lot of your financial regulation and legislation falls into this category. Right? You have what they call enhanced scrutiny that says that's not enough. We're not going to apply the strongest constraints to how we evaluate this, but we're certainly not going to apply the least or the less strict way of doing it. So that's enhanced. Now, what the Supreme Court has clearly said is that we have parental rights, and that when those parental rights are associated with a First Amendment right, they absolutely get enhanced protection. Right? This is enhanced scrutiny. So when the courts review it, there's a higher bar that the legislation and the acts of the government have to meet. Right? So the first thing we do is we say we have parental liberty rights, but we also have, these are also vested in the First Amendment. Because in the First Amendment, you have the right to free speech, you have the right to freedom of religion, you have the right to freedom of association. Right? So as part of your right to free speech, you have the right to communicate with people and express your ideas. When you have children, the fact that you communicate your values, your religious, your moral, your civic values to these children on a daily basis, not only through how you talk to them, but how you interact with them. They want to go to, you have teenagers, they want to go to a movie, and they say, Daddy, give me $10 so I can go to a movie, right? There are conditions that go along with that $10, right? So you get to let that child know what your values are when you hand them that $10. Number one, you're not going to be there with a boy. If I find out you're, sucking face in the back of the movie theater, this is going to be the end of it, right? All of these kinds of values that we put down. And these are our choice, our right to do this. And these are protected by the First Amendment. And because these are our children and we have a right to these rights freely and equally with both parents. So it's not just the parents' rights we're talking about, because you'll have a lot of people that'll stand up and say, oh, what about the kids? What about the kids' rights? Okay? Well, what about the kids' rights? Kids' have the right to receive moral, civic, and religious education from their parents. Do they not? Do they have the right to receive that same thing from their mother as they receive from their father? And shouldn't they receive that equally? They have a right to free association. The government can't come in and tell you who you can associate with. These children certainly have those rights. Now, as children, they can't exercise all of their rights. Those rights are held in trust, but who holds them in trust? Not the government, certainly not the government. The parents hold those children's rights in trust. The parents have a right to determine what those children can and can't do at different levels throughout their lives. As they get closer to 17, 18, they tend to have more rights. All right? So, we've got the fundamental liberty interest. Right? We've got the First Amendment association here, which is very, very strong. First Amendment's protected very strongly, although family courts will trample all over your First Amendment rights all the time, and people don't know how to fight it properly, but they do. So that gets us up to intermediate level of scrutiny, right? And how strongly the courts are going to review this. The next thing we have is that the right to create a family and the right to communicate within that family and the right to make decisions within that family are privacy rights, right? Where are the privacy rights most famous and most strongly protected and most contentious in this country? Anybody? What's the A word?
Abortion.
Abortion, all right? Regardless of your feeling about abortion, this is not about abortion. There are fabulous Supreme Court cases around abortion and the rights of privacy. These rights are solidly codified by the Supreme Court in several cases, Roe v. Wade being one, and Planned Parenthood versus Casey being the other, which are the landmark cases. And there are lots of cases all around them that refine this and tighten it up. And basically it says that individuals have a right to privacy. And there's a whole list of privacy rights that they list in Casey. Right? And privacy rights must be reviewed at the strict scrutiny level. All right? What that means is the highest level, and we'll go through what this means in detail in a minute, but the highest level of review. So what we're doing here, click the next button, right, is now instead of having the judge having broad discretion and the ability to determine best interest and do whatever the judge wants to do, because let's face it, state family law codes essentially boil down to one thing. The judge has absolute power to make any decision it wants, and that's that. And that's every one of them that I've read, and I've read several, boil down to that. And they have all this nice stuff and says only if this applies and only if that applies. Somewhere down in the fine print it says the judge can make whatever decision they need to in the child's best interest, right? And in Florida they say the judge can even do it in the parent's best interest. So if you have children in Florida and you go into divorce, not only can that judge take over the best interest of the child, they can take over the best interest of both of the parties, the adult parties, right? Which is great because that makes it clearly unconstitutional. And we're helping someone with an appeal right now to put all these arguments in it. And that's one of the cornerstones right there, because they absolutely, clearly can't take over control of your life just because you get a divorce. So what we've done here, click again, is we've boxed in this judge. All right? We've drawn a box around him and said, you don't have broad discretion. You cannot determine the best interest of my child. As a parent, I have these fundamental, unalienable rights that have to be reviewed at strict scrutiny. The United States Supreme Court said the parents are the primary decision makers for the children. Primary, number one, first, not the state. Right? So what that means is the state cannot come in and determine the best interest of my child unless they meet a certain bar, a certain trigger. And that trigger, that bar, is defined by strict scrutiny. Click again. So, strict scrutiny is what changes the game for us. Right? This is what I found in writing this book. In this current version, it doesn't quite pull it together as well as I'm telling it to you right now, because the tightness of it dawned on me after I printed the book. The next version will adjust for that. But strict scrutiny changes everything. Strict scrutiny, the rules are, number one, every statute that you test under strict scrutiny, the burden of proof shifts from the individual claiming that the statute is unconstitutional to the state. Now the state has to prove it. This is huge, right? Because if it's anything less than strict scrutiny, you go into court and you say this law is unconstitutional, you bear the full burden of proving to the court that this law is unconstitutional. That's a huge bar for you to overcome, as particularly as an individual with limited budget. Right? Now, if you're a major news organization, you go in and fighting for the First Amendment, you have plenty of money to do this, and you can do it. But parents can't do it. We don't have any money. And by the time you're done with this, you're broke, probably bankrupt. Certainly, you don't have any money to go fighting these kind of big fights. All right? So the burden is one. I'll skip the step here. The first thing is the statutes are presumed to be invalid. Right? Anything less than strict scrutiny, they presume that the statutes are valid. And that's where they catch everybody that when people try to fight for their rights under the Constitution in family law, they go in and say, well, we presume, and it says right in the statutes in Texas and other states it does as well, that it's presumed that these statutes are constitutional. Right? So you have to prove otherwise. Strict scrutiny flips that over. Right? They are invalid. That's the starting point. Now the state has to come in and prove why they're valid. Right? And now once you do this, there's a three-pronged test. It's called the strict scrutiny test. Right? The Supreme Court looks at three things. First thing is the triggering mechanism, and you'll see triggering throughout the book. What is the condition that allows the state to step in and take over? Not only in family law, but in anything. Right? In anything you go to the state and sue somebody or you get sued, there has to be a trigger. Right? And what is that trigger? In strict scrutiny, it has to be a compelling state interest. Not just a state interest, but the interest that is compelling, that's big, that we can see, that has weight behind it. Right? And just saying that, well, we want to look after the best interest of the child, that is not a compelling state interest. It doesn't even come close to meeting the bar. A compelling state interest would say, in this particular circumstance, where there's violence going on, or there's clear and present danger to the child, we want to step in temporarily until we can sort this out, and then we'll follow the Constitution. That is a compelling state interest, right? That is a clear trigger. Police officer comes in, and people are fighting, and the kid's bruised. We want them to take that kid just for a short period of time, right? Figure out what's going on, make sure the child is safe. Compelling interest. Walking into a divorce saying, Your Honor, I want sole custody. That's not a compelling state interest. That's somebody over there wanting your child. Yeah, you were married to this person before, but that doesn't give them the right to take your child. It certainly doesn't give them a compelling state interest. So it gets even tougher than that, though. Sometimes they'll word things and they'll come up with something that looks like a compelling interest, and they'll get past that trigger. The next thing is the statute has to be narrowly tailored. A statute that says a state judge has broad discretion to determine the best interest of the child is not narrowly tailored. It's broad, right? Fails that test. Every family law code I've seen so far, except for Wyoming, which is a glowing exception over here on the side, failed this utterly, because they just blanket give the divorce court judge all the power in the world. Right? Now the last thing, even if they have a compelling state interest, even if they have a narrowly tailored law, the outcome from the act, whatever the judge does, whatever the state does, and they order something, that outcome has to be the least restrictive possible outcome on the rights that are involved. So when we're talking about fundamental rights to be a parent, least restrictive law boils down to 50-50. Right? It means, and the thing you really split is the possession time. You don't really split custody, because married parents have 100% custody. It's in conflict when you're married, but you work it out. When you're divorced, you still have 100% custody. And the test for this is very simple. If the other parent dies, do you have to go to the state and ask for 50% of your custody back? No, you don't. Why don't you? Because it's a natural, unalienable right that resides with you as an individual. Okay? So, least restrictive means that they have to split it down the middle, right? You have your total custody. You have the total right to care for your child. Now, this important terms. The Supreme Court uses care, custody, and control over and over and over again. Right? What does care mean? Care means you provide all the basic needs for that child. You provide everything that allows them to stay alive. 200 years ago, you did it by having a farm and going out hunting and literally doing it. Right? And you may not have $100 to your name all year long. Today, it means you go work in a job, you get paid money, you come back and you provide the house and the food and the movie tickets and all the other things with cash, right, to support this child. If you have that right, you have that right directly to pay for your child directly. Remember when the child asked to go to the movies? Right? You had a First Amendment right to communicate your values to that child. Why did the child have to listen? The child doesn't have to listen, do they? If they want to go to the movies, if they want that $10 bill, they're going to listen to mommy or daddy. Right? That gives you your power and authority as a parent. It strikes into this whole mess of child support. Right? It gets into that and says, wait a minute, what they're doing with child support is a total mess. One of the reasons they're doing it is that the federal government pays them to do child support. It's in the Social Security Act, Title 4D, but that's a different thing. So, strict scrutiny, compelling state interest, narrowly tailored state statute, or state policy. It doesn't actually have to be written down. It can be a policy in general, but it has to be narrowly tailored, and the outcomes have to be least restrictive. Right? This is a huge, huge, huge burden for the state to overcome. Right? And I have yet to see any family law code, except perhaps for Wyoming. I haven't studied it in detail, but it's essentially based on these ideas. Right? They simply can't meet the bar. And the whole, and I mean the whole, child custody situation in divorce is about to be turned on its head. Everything's going to have to change. And it's going to be a watershed when it happens. It may take us several years to get enough people pushing this and talking about this, filing this in their pleadings before it catches hold and these courts realize they can't keep this lie up anymore. And that's why you guys are here, because you're the first wave of people who are going to walk in and make this argument in front of these judges. Next slide.
This is where I come in and I try to make a little more sense of what he's telling you to apply to your individual cases. And that is, when he talked about you have all these rights, but you went into court and none of that happened that way, right? So what he means is you're the first wave, you can go in and present these to the court, is that now you are aware that you need to look at your pleadings for certain things. You need to take out the words that say the judge has broad discretion. And you need to put in those things that he said and put the argument like he said it. Here's why you have to use strict scrutiny. You actually put it in your pleadings. Now, a lot of attorneys don't do it that way, but I'm assuming that once things progress after a while, you can no longer afford attorneys and you're doing it on your own. As a pro se, it's more important for you to put these things in writing in your pleadings, because there are times when you'll either forget to say it when you're in court, or they just won't let you. They'll threaten you, whatever they do, and then it's at least in the record. So if they choose to decide against you, you have that in your file, and an appellate court will look at it. If it's not presented and it's not in your written pleadings, they won't. So that protects you. So you want to put in there that you don't want the judge deciding best interest, because that right resides with you until or if they prove you unfit or clear and present danger. You also want to request that they use strict scrutiny. I don't know if any of you remember in any of your pleadings, but a lot of times they'll put down, like the other side will respond and they'll say, we want you to review this case under the following standard, and they'll say like preponderance of the evidence. Any of you remember seeing it? Okay, you want to put strict scrutiny, and I bet you none of you ever saw that in any of your pleadings, right? And that's the reason it doesn't happen. When you go into court, attorneys or yourself, if you're serving as your own attorney, are the persons that are supposed to be guiding and advising the judge. I know that sounds strange because you're dragged in there like you're supposed to be there to be told what to do. And when you frame that way and you present yourself not confident and hey, judge, tell me what to do, they're fighting me and I want you to side with, that's what they're going to do. But if you go in there and say, Your Honor, I'm respectfully advising you, I'm just trying to present to you what I've researched and found, that these are my rights and I would like you to protect those rights. I would like you to honor these rights and use this standard. So you just nicely say it to them if they allow you or have it in your pleadings. Then they're not going to be quite as combative with you. When they start to get angry with you, that's generally because they're starting to feel threatened. Okay, so now you're threatening the judge's power. You're threatening their attorney's power. You're not paying one, or you're changing up their politics in some way. Things that you have no clue about, you shouldn't even need to worry about. Okay, but that's what's happening. So realize if they start to attack you, to step back and remind yourself while you're there, and just to remind the judge respectfully, and then just object if they're going to choose to take the same course that they do. If he says, no, it's my authority, I can determine the best interest, and you say, okay, I just want to object for the record, and that I'm reluctantly going along with what you're doing because, you know, I'm under duress. You're telling me I have to. So many parents don't say that. And then when it gets to the appellate level, if you didn't say some of those things, they say, you agree. They get you off that track, okay? So now you have in your head, you're confident, you walk into court and you're like, all right, I'm going to stand up for myself, nobody's going to get in my way. And what do? You two have to get along. I'm not taking your rights. If you don't get along with this parent, I'm allowed to intervene because now your rights are in conflict. They're not really, not all of them, okay? So the way I would recommend you handling that is, Your Honor, there are some rights that will be in conflict, like maybe if we disagree what school the child goes to. But my right to spend time with my child equally doesn't have to be in agreement with the other parent, because that's an individual right. That right belongs to me just like it belongs to them. And that right can't be destroyed just because the other parent wants to take it from me. Okay? And so you just learn ways to communicate it to them. So don't go off your path and get intimidated. Just say, I don't believe that that's really the way this should be interpreted, and you frame it for the judge. The judge is going to turn around in most cases and say to the other side, because they usually have an attorney, do you agree with this? What's your interpretation of it? And they'll go through, Your Honor, the statute authorizes you to do this, and they'll go right back to that. You just say, Your Honor, I object. I believe that statute is actually not using strict scrutiny and it's in violation of my rights. And then he'll probably disagree with you, but you have it on the record. So then the next thing is you don't have rights until the court awards your rights. I think you understand now that you do. The only thing the court can do is take them from you. You already had those when you were married and in divorce. Children's rights are being ignored if you don't give them a choice between parents. That's a huge one because the courts get inflamed very easily. And especially when you're involved with a parent that's alienating. The courts can very quickly start to side with that alienator because they invoked their personal beliefs and their bias. And they start to believe they need to protect your child from you. Okay? And that happens because the court is already set up thinking they need to make a choice. So as soon as one parent is, made out to look worse than the other, they think that that's what they need to do. So if you don't stick to your guns and you don't frame this strongly, then you're not going to be able to overcome that. But if you did, and the other parent tries to convince them, oh, Your Honor, that you can't give my kids
to the mom or the dad, they don't put them to bed on time, they don't feed them healthy meals, then you say, Your Honor, I'm sorry, but those are family privacy rights. My child's not starving, I'm supplying the basic minimum needs as required by state law. Is this court saying they're going to treat me differently than they did a married parent? And so you just put those ideas out there because the judge probably isn't thinking about those either. And so you can't be scared. When they intimidate you, you forfeit your rights. If you finally just give in and say, fine, we'll go in the other room, we'll try to come to agreement. Now you made the judge think that, okay, if you don't come to agreement, he's going to break the disagreement. Okay, so you've got to stick to it. And I know that's really hard. I went through it. I even had a judge at one time tell me, go in there and agree to child support and all this stuff. And it's probably on a later slide. But the way you get out of those, I did go in the other room, but I didn't come to agreement. I kept telling the judge, no, 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 no. And then when I went in the other room, I realized, wait a minute. They didn't even plead this properly, so I just sat there and let them try to beat me up, make me feel guilty. You should do this for your kids. It's what they want. All of this stuff. Didn't agree. Lawyer got upset, headed back into the court, and he threatened me. I'm going to tell the judge, you're not cooperating, right? We've all heard that. Fine. Tell the judge I'm not cooperating. So he went in there. He tried that, and, Your Honor, it's not properly pled. They didn't ask for this. So if you ever see that they try to ask for something they didn't plead, that will shut it down. A lot of people don't realize that. And attorneys don't usually do that. They just allow them to throw things out and they fight. But no, make them plead things properly. That protects you. Okay? And especially if you're pro se, that they'll usually be okay with you saying that and then tell them to properly plead or whatever. If you have anything you can plead, that's enforcement issues or anything else, ask the judge to hear those first. Okay? So if they're interfering with your ability to exercise your rights, because so many times when you end up in some of these temp hearings, they have kept your child from you or you know, they've done something that is interfering with your rights to get that benefit, you need to point that out and you need to ask the court to hear those things first. It's very, very important because that will set the stage. And I know so many of you get told, don't be litigious or don't appear like you're not cooperative or you're wanting to fight. But unfortunately, that's the wrong advice. Just like counselors used to give the advice, give your child time, you know, let them relax. Wrong advice, right? Same thing in court. When they tell you, don't attack the other parent, don't punish them in court, wrong. You have to do that because if you don't, they're going to attack you and you're going to be left with no child and no effectiveness. You'll have no authority.
So there are a number of other things that are supposed to be on this slide that haven't made it there yet. They're in the book and it's in chapter 2. Some of the other fallacies. We must have a primary parent. Where did this come from? This came from 300, 400 years ago when we had kings. We didn't have legislatures. We didn't have Republican government. We didn't have Democratic government. We had one man sitting at the top in control of everything. So this idea that a family is a hierarchical unit with one, back then, man sitting at the top of this whole family structure is the whole basis for this idea that we have to have one parent. It's total hogwash. It's against the Constitution to start with because we have to be treated equally under the Constitution, right? Men and women are equal under the law, period. Right? So you have no basis to set up that you have to have one. But this is something that's carried on for so many hundreds of years that it's deep in our psyche. There is a fundamental, individual and institutionalized bias and prejudice against divorced parents. And it runs throughout our whole society from people on the street, married, divorced people carry the same bias. Right? You will see, sometimes it happens, family members, where family members that are even divorced and remarried will put these same biases and prejudices on you when you get divorced and treat you badly and think all these horrible things when you get divorced, even though they went through it and they know that they weren't horrible people. And yet they do all this stuff to you. Almost, it's by default. They don't even think about it consciously. They just do it. And this idea that there has to be one, that's one of those big ones. The idea that the child only has to have one home, that the child can only be settled if they have one room and one place where they spend all their time. Where'd that come from? That's total hogwash. They have no basis for this. Our children have 2 of everything. They have a home. My child has 3. My ex-sister-in-law and ex-mother-in-law lived with us for about 6 years. They bought a house about a mile away. My daughter has lived there as much as she's lived with her mother. And so she has a room there, a lot of stuff there. She has a room with her mother. She has a room at my house. And she has stuff at all of these places, right? Now, financially we can do that. Not everybody can do that. But it works. And she goes back and forth on a daily basis and every other weekend. And she spends her time equally. And she has her room. And she's comfortable. And she's well balanced. And she's a good, normal, natural child. It works. Right? Parents have to get along for equal custody to work. Why? All parents need is a set of rules that the court will enforce. Right? You will deliver and surrender this child by this time, on this day, every other week, whatever your equal schedule is. If you don't do so, you're going to jail. Right? If they enforce that, why do you have to get along? It don't matter if you hate each other and don't talk, as long as that person delivers that child and you in turn deliver when you're supposed to. Don't have to get along. You have to have defined agreements, right, or defined orders by the court, and those have to be enforced. Why today you have to get along? Because most judges won't enforce their orders. They're meaningless, right? Or they'll only enforce them if they don't like you, right? But they don't. You have parents, particularly alienating parents, that get away with it, violating order time after time after time after time. I know one case in particular where there were over 250 violations, right, before anything was done. Courts must protect the status quo. Again, what's so important about this one particular instant in time where somebody decides to file a divorce? Why do we freeze every family decision from that point and say this is the way things have to be for the next 20 years? It's absurd. Right? They do it in custody considerations. They do it in alimony, in states where there's alimony. Right? That moment in time is what gets crystallized forever. There's no basis for it. Now, in the short term, temporary orders, 2 or 3 months, while you're sorting things out, maybe. I still don't like that, maybe, but certainly not long term. Right? You have to be allowed, when you divorce somebody, to restructure your life, restructure your environment to suit your needs and your child's needs based on the changing circumstances. If you had a job where you traveled, most of the time you provided the money, the other person stayed home and took care of the child. That's untenable after you get divorced. You were able to travel and do all that stuff because the other person was at home taking care of your children, sharing your values and ideas with those children. Agreement breaks down. I may not want to travel as much. I'm going to stay home and spend that time with my child. I certainly did that after I got divorced. Until I got remarried, I travel most of the time now. But that was a decision that I had a right to make. It's a protected privacy decision. Right? We have to be free to make it. Divorce courts want you to freeze it and say, no, you can't do that. Particularly if we charge you with alimony, and you were making $100,000 a year when we charged you with alimony, and you want to work half as much and be home with your child, that's fine, but we're still going to charge you alimony at $100,000 a year. Absurd. Now that doesn't happen in Texas, except under some very specific circumstances. But other states, it's terrible. Parents in divorce are no longer able to put their child's best interest first. Who says? I certainly did. She certainly did. Right? You absolutely can. And until proven otherwise, that's what they have to assume. Under the Constitution, they must assume that fit parents make the best decisions for their children. And the only way they can overcome that is through a strict scrutiny test. Right? So they can't just walk in and say, oh, well, you're getting divorced, you can't make the best decisions anymore. Hogwash. You can. And you do. And you have a constitutional right to it. They must assume it. The parent's rights and the child's rights are in conflict. When you get divorced, all of a sudden they say your rights are in conflict with a child's. No, they're not. They're the same as they were yesterday. Right? And the Supreme Court has specifically said, this isn't a rights termination case, but they're said the state must assume that the parent's rights and the child's rights are together that are joined until the point where the state says you are unfit. Until they go through this full big hearing that usually takes a couple of years and say you are unfit. Until that point, they must assume that your rights align with the children's rights. Your interests align with the children's interests. It's very clear, black and white. This is a big one. This hit us. I found the Texas Supreme Court case that talks about this, where the Supreme Court criticized one of the parents because they did this. Parents who fight for their rights don't put their child's needs first. All right? Judges will sit up here and tell you, you need to stop fighting for your rights and you need to focus on the best interests of your child. Well, number one, my child's best interest is best served by me retaining my parental rights to determine what's in her best interest. There's no way around that. And if the court's going to make an order that says they're going to violate my child's right to equally have time with me and to learn everything that I'm going to teach that child, then they can't be acting in that child's best interest. Okay? They're by default violating that child's rights, which cannot be in that child's interest, except for some very narrowly tailored circumstances that don't happen in the vast majority of these situations. And we have other mechanisms to deal with this. Imperfect mechanisms, as anybody who's dealt with CPS knows, but other mechanisms. Yeah. We have a whole list of these. I don't think we have time for me to keep going through them, but these are important because these are where the fundamental bias and prejudice comes from, and it's deep-seated over hundreds of years.
And I do
You've got to break these.
I want to mention something on that too. If you do have opportunity to get the book, we're also donating one to the PAAO USA North Texas Chapter Library. So if you have a chance to come in and read that chapter, it's chapter 18? The chapter you were just...
Chapter 2.
Okay, chapter 2. If you have a chance to read through that chapter, it's really important because that'll help you change the way you argue those things in the courts.
You can also look Google Books. At least 20, I think it's 20% of the book is available on Google Books.
Yeah, but they jump around.
Books.google.com, or you can see the book online. So you can get a lot of this just by going to Google and seeing it. Not everything, and it'll cut you off at an opportunity.
Yeah, they jump around pages. You can't choose the chapter. A lot of those things that he was mentioning, how many of you went through a time period where you felt like, oh my God, how can the judge side with him or her when they've lived with me my whole life and I stayed home and took care of them? Okay? So basically you went into this believing that you had to prove you were the better parent, right? And that is how they framed it. But unfortunately, if you had known these things, you would have known that even though you have those feelings because you're a parent and you want to protect your child, that wasn't the way to represent it in court. Okay? In divorce, you're going to have to split time with the child. The child is going to have to experience other things, and that's what I meant at the beginning, which was so hard on me because I went through that. Saying, oh my God, they've gone to the same schools, they've lived in the same neighborhoods, and he traveled all their, and so I went through all of that. And then I realized that I walked right into what the judges are used to having to decide, and that's, okay, you guys are going to sit here and beat each other up and you're going to argue about things instead of presenting to me that you have rights, then I'm going to make a decision. And that's where they think they need to go. Now, as a judge, they should know the laws. They should know they're supposed to be upholding the Constitution and your rights. And as again, I said earlier, they should be informing you.